Thank you, Mr. Medina. I'll begin the questioning, and we'll start with Deputy Attorney General Cole. Both the P-Club and the review group have questioned the value of the bulk metadata program. Congress has been waiting for a long time for the administration to explain exactly why bulk collection is crucial to national security. So, Deputy Attorney General Cole, this is the administration's opportunity to explain to Congress why bulk collection, as opposed to other intelligence measures, is necessary to protect our citizens.
Well, Mr. Chairman, I think to understand this, we first have to understand the value of trying to make the connections, connect the dots between people who we know are involved in terrorist activity or have reasonable articulable suspicion to believe are, and the other people that they may be acting with, both inside and outside of the United States. That's a very useful tool. It's not the only piece of evidence you would need in an investigation. And in fact, in my years as a prosecutor, there's rarely one piece of evidence that makes the case. It's a whole fabric of evidence that's woven together, small pieces that relate to each other, that become useful once they're compared with and connected with many others. This is a tool that gives us one of those information, the connections from one person to another. And in order to be able to get it in a useful way, the initial view and the most expeditious way to do it was to have the bulk collection of the mass of telephone records with significant restrictions on how we could access it, so that we could, when we find a phone number associated with a certain terrorist group, we can search through the other records and find those connections. Now, we can find other ways, and we are finding other ways, to try and approximate and gain that same kind of information.
Let me ask you about one subset of that that's very, very important and seems to be the thing that concerns many people the most. The President's Review Group has recommended that the storage of bulk metadata be transferred to a third party or to company storage. The President also indicated that it's his preference as well. How does third-party storage protect Americans' privacy more than government storage? And does the President have additional ideas for reform beyond third-party storage?
Well, Mr. Chairman, we're trying to work through the best way to go about this. And the President has given us this direction, and we are looking for all the possible alternatives. The President's Review Group made that recommendation. The P-Club noted that there are issues with all of the different alternatives that you can use here. I think one of the issues that comes to mind is that the government has certain powers that private groups don't have. And there is a concern among the American people when the government has possession of all of those records and the powers that go with the government, that they would prefer that the government not have those records, that some private party have them. Obviously, we need to make sure that strict controls are put on, as they were when the government possessed the bulk data, to make sure that they're not abused. And it's very, very important to make sure that those strict controls, as had been done under the bulk collection, are continued regardless of where these records reside.
Let me ask you one follow-up to that. That's really a critical question here. The third-party storage is really an idea that's still in progress. If the administration finds that third-party storage is not a viable option, what would be the President's recommendation for moving forward? Continue the bulk collection program or ending it?
I think that's the process we're going through right now. I don't want to try and get too far ahead of it and hypothesize about where we may end up by the time we have to make recommendations to the President and he makes a decision. But obviously the providers...
Well, you've heard the ranking member. There's legislation before the committee. There are other legislative ideas than the one he referenced, but he and many others are chomping at the bit to move forward, and having the administration's position on this critical aspect of this is important. So we need to know the answer to that sooner rather than later.
And we're working on trying to get that answer, and we'll provide it to you. The providers already keep these records for a certain period of time, and some keep it longer than what is required under regulations. And so we have to work through what we think is the optimal period of time that the records need to be kept if there's going to be a provider keeping its solution.
And I want to direct one question to Mr. Medina before my time expires. The P-Club majority recommends ending the bulk collection of telephony metadata under Section 215. The majority also recommends, however, that the program continue with certain modifications. Why did the majority not recommend the immediate end to the program?
The majority looked to how other programs have been discontinued when, say, courts have struck them down. Even the Supreme Court has found programs unconstitutional, and nonetheless gave the government an opportunity to transition to a new program. And so rather than shut it off, we followed the approach the courts have taken, which is to say, let's quickly transition into another, either keeping the information with providers or if some other mechanism is developed.
You're talking about courts in other cases, because
in other cases, not in this case.
I haven't heard them say that in this case.
Precedent of how, if a program has been found to be illegal or unconstitutional, the courts oftentimes don't just shut it down, but give an opportunity to transition. And we thought that, especially since we're not a court, it was reasonable to recommend that there be a period of transition, hopefully brief.